appeal in the matter of Sullivan and Burt Street Capital Limited.
Yes, Mr. Mills.
Yes, my lady, my lords. I, of course, appear for the appellant. My learned friend Mr. Lee for the respondent. A man who modelled his life around a paranoid, persecutory delusion that he was being followed by a Russian gang for 4 years did not meet the definition of disability under Section 6 of the Equality Act. So held the London Central Employment Tribunal in the judgment from which this appeal arises. It is the appellant's contention, and if I interchange between appellant and claimant, forgive me, but it's one and the same individual, that this conclusion is so contrary to the letter and statutory purpose of the Act that something has gone awry, and we say it has. This is an appeal which raises important issues as to the correct approach to assessing whether an individual is a disabled person pursuant to Section 6 of the Equality Act, and when an employer might be taken to know about that disability. It's important to understand, and I'll explore this in due course in a little more detail, that the two jurisdictional questions you're faced with, disability and knowledge, are threshold conditions for the ability to pursue a complaint of disability discrimination at all. Set the bar too high, and the purpose of the statute is thwarted. And the claimant says that the tribunals below did just that. They misapplied the law in concluding that there was no substantial adverse effect throughout. They erred in the approach to recurring conditions and likely duration, and they erred in concluding that the respondent lacked either actual or constructive knowledge of disability. Such are the potential consequences of the decision below, that the claimant is supported by the Equality and Human Rights Commission in this appeal. It is particularly concerned as to the impact of this decision and the decision of the EAT on the coverage of mental health disabilities, and therefore also asks that this appeal be upheld.
Well, can I just ask some questions which may seem a bit basic for
no such thing, my
specialists. This is a case in which your client part succeeded
Yes.
Before the tribunal, in that it was found that there was unfairness
Yes.
in relation to his dismissal.
Yes.
But he was unsuccessful in regard to the application, the issue that is before us on this appeal.
Yes.
Can you just spell out for us why it matters?
What the practical consequences are.
Firstly, what did he achieve by his success so far, and what does he hope to achieve by further success?
Yes. The claims of disability discrimination below were indirect discrimination, a failure to make reasonable adjustments, and discrimination arising in consequence of disability. If successful on those claims, he could hope to recover an award for injury to feelings. He could also hope to recover or may obtain declarations and recommendations in respect of this employer. In terms of pounds and pence, there's another important consequence, which is something I address in the submissions on disposal, if you're with me, on the substance of the appeal. But we see it at paragraph 119 to 120 of the judgment, page 134 of the core bundle.
When you're going to refer to the judgment, you're going to refer to the tribunal, original
Tribunal judgment.
Yes.
It's common ground between my learned friend and I, and indeed it's well-established law that your focus is on the decision at first instance. That is informed, of course, by what the EAT has to say, but the primary focus is on the decision of the tribunal. The ET's decision, page 134 of the core bundle. Wait, if I take you a little bit further back, 115 first, page 133 core bundle, paragraph 115.
Yes.
By this stage, the tribunal's concluded no potentially fair reason for dismissal and a fair procedure to the extent that there's an uplift of 20% of any damages recovered. The next question is, what is the measure of loss of that unfairness? Had this employer acted within the band of reasonable responses in accordance with Section 98(1) of the Employment Rights Act, what might have happened with his employment? And it's well established that the band of reasonable responses test, the gauge for unfairness in an unfair dismissal, is broad and not a question of substitution for the tribunal. We see where that reasoning goes by reference to a case of Polke, familiar, no doubt, to at least some of the three, but essentially, what would a fair process have eventuated? And it's a means of gauging the measure of loss for an unfair dismissal claim. And what the tribunal concludes, 119 over the page, the respondent would have been acting reasonably in imposing warnings and would have been acting reasonably in dismissing within 6 months. And so there's a long stop of 6 months.
Yes.
What the tribunal does not do, because of its earlier conclusions, is have due regard to the positive obligations an employer might have had the claimant been disabled throughout.
Yes, I see. So had you succeeded in relation to disability, you say the paragraph 119, 120 calculation would have led to a different outcome in your favour?
It certainly cannot be safely concluded that the same would follow. At the very least, I say that. And I indeed go further and say 6 months, having regard to the duty to make reasonable adjustments and the duty to refrain from treating an individual unfairly because of something arising in consequence of disability, which may include questions as to the extent to which lateness or attitude or whatever it might be was attributable to the disability.
So am I
as a whole
on safe ground for our purposes in understanding that it doesn't transform the basis for compensation? What it does is it would have fed into the calculation of compensation that should be, you say, due.
And there's a final point, of course, when it comes to measuring compensation, which is that there is no statutory cap for discrimination, whereas there is a statutory cap for a claim of ordinary unfair dismissal.
What is the statutory cap now?
74-ish, I believe.
In a nutshell,
I'll be corrected swiftly if I'm wrong, but
that's fine. But in a nutshell, if I understood your answers to my lord correctly, if I put it this way, that even the findings in relation to unfair dismissal cannot, on your submission, be cleanly isolated from the complaints about disability discrimination.
Quite so.
So they might need to be revisited depending on what conclusion we come to.
Quite so.
All right.
Had you finished in answer to my first point?
I believe I have, in a nutshell, declarations of discrimination, the power to make recommendations, injury to feelings, uncapped damages, and
for the uninitiated, what is the bracket of injury to feelings that one
it
sees
can
in these
go
cases?
to 35,000, and in exceptional cases beyond.
Even in cases of indirect discrimination?
Yes, the measure is compensatory. And the question is, even in a case of indirect discrimination, what injury has this individual suffered? And the claimant here has lost his employment.
Right. Now, I have only one other question before I get out of your way, which
Not
is
at all.
To do with the Commission.
Yes.
You dropped into your discussion that you're being supported by the Commission. To put it bluntly and without disrespect to the Commission, what's that?
They're paying our bills. in short, they are funding this appeal.
Right, but it obviously has no bearing at all on any order or conclusion that we might reach.
No. What I would say is that such is the role of the Commission and such are its budgetary considerations and its priorities that it does not fund every appeal.
I know,
far from
but
it.
with all respect, if the if the CBI decided to fund your opponent, I don't suppose you'd be thinking that ought to influence us one way or the other.
Save that the Commission has a statutory obligation to...
Yes, but I mean, as far as I'm concerned, I wasn't aware that the Commission had taken any view on this. It hasn't asked to intervene. It hasn't provided submissions. And so I'm a little bit anxious about a situation that, as it were, counsel for whatever party tells us we've got so-and-so on our team. Can we park that at the moment?
We can, if it raises, if it becomes relevant at any subsequent stage, the submissions that the appellant makes are the submissions the Commission make. They are one and the same. So the submissions that I put before you on behalf of the appellant have been approved.
I'm not sure I'm at the moment reassured by that, because in my own experience, at least, where the Commission wishes to be heard, as it were, declares itself, and the court considers what role, if any, it should play in it. We can't have a shadow presence, and I'm not sure at the moment that either you or the Commission are entitled to say that the submissions you make to us are the submissions of the Commission.
Well,
there's been no preparatory work for this. I mean, evidently, when the Commission takes part in proceedings of this sort, its contribution is valued and respected. It isn't always successful, but it's certainly valued and respected, and it has a defined role in the legal landscape.
Yeah.
So everybody knows, and at the moment, your submission that, as it were, the Commission is your alter ego, and that Mr. Sullivan speaks with the same voice as the Commission is something I find a little troubling.
Well,
they may have a conflict of interest at any particular point, which we wouldn't be aware of. Anyhow.
Right.
There we are.
Let me turn to the background of the claim.
Just before you, Mr. Wilson,
yes, of course.
Sorry to interrupt you again. Can we just see what the lie of the land is in this appeal? Because I may have missed something, and forgive me for that. In the core bundle, page 72, we have the reasons which the judge below gave for granting permission.
Yes.
And from the next page, we can see that that document is dated the 22nd of September last year.
Yes.
In the previous tab are the grounds, at page 11 are the grounds.
Yes.
Tab 3. And that document at page 14, we can see is dated the 23rd of October last year.
Yes.
About a month after the grant of permission. And I was just struck that it seems to follow, therefore, that can't have been the document which Mr. Justice Choudhury had before him when he granted permission to appeal. Can you help us with what he did have in front of him?
He had a document which looks very similar to that at 11 to 13.
But you say very similar. Can we see it?
We can. I can certainly get hold of it.
So it's not in the bundle.
It's not in the bundle.
Yeah. Well, I certainly like to see it.
I understand
that because it's very important for this court to understand completely what are the grounds.
Yes.
The grounds of appeal in this court are only those grounds for which permission has been given.
Yes.
And I'm afraid, to my mind at least, I get worried when I hear advocates say things like very similar to, unless they're identical to. I'm not sure what we've got at pages 11 to 14. Anyway.
Well, at 11 to 14, clearly I can't say it's identical, not least because the date is different, for example.
Yes.
But in terms of the structure and the material content, ground 1 on substantial adverse effect, ground 2 on recurring condition, ground 3 on knowledge, those are the very same numbers that are addressed at page 72.
All right. That's fine.
The other thing, get hold of the version that was before the EAT.
Yeah, thank you. If that could perhaps be
Yes.
emailed to my clerk in due course, that would be helpful. Just as a final point on this topic, I think in fairness to you, certainly speaking for myself, I should say that as a judge sitting in this court, I am always very interested to know exactly what the grounds of appeal are. And I stress grounds as opposed to arguments.
Yes.
And so, I mean, if we just look at the document at pages 11 to 14, although there are numbered 3 grounds, which we can see in bold, and that's clearly something like what the judge had in mind, as he referred to 3 grounds at page 72. What I see beneath each of the numbered grounds is a lot of further points being made. And I'm not, speaking for myself, entirely sure whether they are sub-grounds of appeal, because many of them seem to raise distinct points of law. Whether they're simply arguments in support of the numbered grounds. And then we will have to think very carefully about the 29-page skeleton argument that we've received in this case, because it may be that everything you say in the skeleton argument is one of the permitted grounds, or it may not be, but we'll have to think very carefully about the points that are raised in the skeleton argument, because I've said this in many appeals now in this court, that you can't just advance points in a skeleton argument. They have to be covered by the grounds of appeal for which permission has been granted. And it may be that they all are, but I just wanted you to be on notice, in fairness to you, that we may be interested in that subject.
Noted, my lord. I believe that they are.
All right.
And certainly that the grounds were the benchmark for the skeleton. The skeleton, of course, contains arguments in addition to the grounds, but not discrete grounds. There is no.
Well, can I put it to you bluntly? One thing that has interested me is that at times in the skeleton argument, you allege that the ET's findings were perverse. Now, is that one of your grounds of appeal in this court?
Perversity is not cited in the 3 grounds.
Right.
You're right.
Okay. So, well, anyway, I'll let you develop your arguments in due course. But I just, speaking for myself, I think in fairness to you, you need to be aware that I will look very carefully at any assertions that are made that the ET's findings are perverse, because I do not regard that as one of the grounds of appeal.
Understood. Turning to the decision at first instance, which we see starting at page 109. Much of the factual background, certainly prior to 2013, is not contentious. The respondent is a wealth management company led by Mr. Robert Drake as CEO and Mr. Mark Hodgkin as COO. In 2008, the claimant began employment as a senior sales executive for some 5 years before the events in question. And it's right to acknowledge, and the claimant does, that there were some sources of tension prior to the events with which this appeal is concerned, paragraph 15, page 112. Matters took a significant downward trend, however, in 2013. We see this at paragraph 22, page 114 of the judgment. 24 is perhaps where, 23 is perhaps where it starts. It's accepted that from March 2013, the claimant believed that he was being followed by a Russian gang, and that he believed that the events that he perceived were real, end of paragraph 23, up to the point of dismissal. And indeed, the tribunal goes further and says that it's still something he believes is happening to him today being November 2018. It's similarly clear that was obvious to the employer. Paragraph 26, Mr. Drake was said that the claimant was completely fixated with being stalked by Russians. This was overshadowing everything in his life. Mr. Drake said that the claimant was in a bad place psychologically.
Can I just say this, that we're obviously well on top of the facts as they appear in the findings, and nobody's seeking to depart from those.
No.
And so I think, quoting from individual emails and so forth, we all know where that leads in terms of the answer. So you can, I think, tread lightly on these matters.
Yes, understood. Let me pick up, therefore, with the substance of the tribunal's analysis on the questions before you. It's accepted that the claimant's delusion persisted for the 4-year period at 98.7, page 131. The tribunal also accepted that the delusion had a substantial adverse effect for 2 periods. In 2013 and latterly for a period of around 5 months in 2017. For the reasons that it gave at paragraph 98, however, the tribunal concluded that it did not have that effect in the interregnum period. What the tribunal did not do at any stage in its analysis is identify what exactly the effects were and why they were no more than minor or trivial in the intervening period. I'll take you in due course to the construction of the Act, but of course the tribunal then had to consider whether at the point of dismissal it was likely, it could well be, that there was a recurring condition here, or that it would last, the effects of the condition would last for more than 12 months.
All of these are matters of fact.
Well, we say these questions are ultimately jurisdictional in nature.
Yes,
there are legal tests.
These are, of course, there are legal tests, and that's why people find facts. But all of the matters that you've been, as far as I'm concerned, correctly identifying as being the crux of the decision are matters upon which the tribunal was called upon to find facts.
Which must be supported by reasons, and the right facts must be found.
Yes, but I don't think we're only attempting to identify what we're doing here, which is to, as I understand it, say that your focus is upon the fact-finding, or you might say lack of it, of the tribunal.
Yes.
And it is an attack upon their fact-finding performance.
Well, it's the fundamental challenge is, has the applicable test been applied to those facts, and where conclusions have been reached, are they adequately and appropriately reasoned? In circumstances where the only analysis of law is confined to 4 paragraphs. 89 to 92 of the judgment is the sum total of the tribunal's direction on the law. Cite section 6. Cite section 212(2) on minor or trivial. The only authority cited is SCA Packaging and Boyle. For example, the guidance which an adjudicating body must have before it, must consider, does not make a mention at all. And I'll come to the relevance of that in due course. The Tribunal's approach to the medical evidence, we see at paragraph 96, the issues as to impairment and effect are not matters for a decision by medical experts, but by the Tribunal, to be distinguished from purely diagnostic or clinical conclusions. And then the reason for departing from the jointly instructed medical expert, the only reason given, paragraph 98.6, is that Dr. Wise, who prepared a jointly instructed report, responded to written supplemental questions, and then gave evidence at Tribunal, Dr. Wise said that he could not be sure about the impact of the claimant's condition.
Now, when was he instructed? About a year after these events, I understand.
He was instructed a year after these events, which is the ordinary course in terms of identifying a jointly instructed expert.
So why is the Employment Tribunal bound by his opinion as opposed to taking into account all of the evidence, including contemporaneous evidence, for example, from other employees?
A tribunal is not bound, and it's not part of the appellant's case, to slavishly follow a medical report. But if it's going to depart from it, it has to give full and cogent reasons for doing so.
But it has to give adequate reasons for doing so. And really, the thrust of your argument, as far as I can see, is that what they said at paragraph 98 doesn't amount to adequate reasoning.
Yes. Particularly where the tribunal also had the medical notes of another psychiatrist, Dr. Watson, and a full report from Dr. Watson, which I'll take you to in due course.
Dr. Watson didn't give evidence.
Didn't give evidence.
So what's the status of the report from Dr. Watson?
Not dissimilar to the status of many reports in this context, which is that it is not questions of weight on that report are obviously for the tribunal. It was admitted, and it was something which we say the tribunal had to take at least some account of. What it provided was a clinical analysis of the claimant's state in that interregnum period between the 2013 and the 2017 flare-up.
And what are Dr. Watson's qualifications?
She's a psychiatrist. Psychologist, forgive me. Psychologist. Chartered psychologist.
Right.
Her report, I'll take you to it in a moment, is at pages 6 to 8. That report is based upon medical notes from 2014, 1 to 2, and a telephone call later, after the material period, but she's clear in her report, we say, as to when she's talking about what happened in the past and when she's talking about what she later became aware of following a discussion in 2018. We also have her instructions that were put before the tribunal in the bundle to prepare that report. They are at pages 4 to 5 of the bundle.
The supplementary bundle.
Supplementary bundle. Claimant obviously appealed those conclusions, and the EAT dismissed the appeal for the reasons summarised in my skeleton at paragraph 25, pages 13 to 14. That's the background, the legal framework, and then I will address you on the grounds in turn. We are, of course, concerned with the application of the Equality Act. Tab 25, I hope the revised version of the authorities bundle has reached my lady and my lords. It was largely replicated from the EAT version, where, of course, the EAT has the benefit of a discrete handbook, and so the glaring omission in the version that made its way to you was the
Tab
Equality Act
25.
itself. Tab 25. The legislative purpose is reflected in the long note or the long title of the Act, restating the greater part of the enactments relating to discrimination and harassment related to certain protected characteristics, including, of course, the Disability Discrimination Act of '95. And then the structure, the protected characteristics, is set out in section 4, forgive me. Section 6 defines disability, substantial and long-term adverse effect on a P's ability to carry out normal day-to-day activities by reference to an impairment. No dispute here that there is an impairment, that the impairment continues for 4 years. The focus of this appeal is on section 6(1)(b). And then we have the various discrete provisions dealing with the different guises of disability discrimination.
I mean, before we dive into the all the help we're going to get about this,
Yes.
I mean, 6(1)(b) is a pretty straightforward workaday description of what we're concerned with here. Something is or it isn't. What is described there in that line?
Yes, informed by Schedule 1 of the Equality Act.
Yes, which helps about that. But in the end, the fundamental question that has to be answered is, did your client fall within 6(1)(b) or not? That's the ultimate question for the tribunal.
On proper statutory construction, in particular, of what 6(1)(b) says, yes,
Yes.
of course, yes.
I understand. I perfectly understand that there's plenty of help coming, but that's what the statutory.
That's what the statute requires.
Right.
Yes.
Thank you.
And section 6(5) is the source of the power to issue guidance. So that's how the guidance fits into the picture.
The guidance fits into the picture, yes. And we see, just whilst we're on the guidance point, Schedule 1, Part 1, starts, if you're following the numbering of the internal numbering of the Westlaw extracts, page 194.
I'm sorry. I'm working off a numbered
There?
bundle.
Forgive me. Do you see, my lord, numbers in the top right-hand corner?
Yes, but ours don't have 194. They go up to 24. Sorry, 34.
No.
Sorry, are you looking at paragraph 1 of Schedule 1 to the 2010 Act?
At this stage, Schedule 1.
So I've got a 194 in the top right-hand
Yes,
corner.
that's what I'm looking at.
That's behind the next tab.
Oh, is it?
Yeah.
Oh,
It is in mine. Anyway, don't worry, I've got that now.
It's a mystery. Okay.
I've got it
As long as we're all
same
looking at
time.
the same provisions,
Yeah,
then
got it.
that's a start.
Got it, yeah. Schedule 1, Part 1.
Schedule 1, Part 1 is the schedule of the Equality Act,
Yes.
which assists on the
Right.
correct legal approach to disability.
Yeah.
Long-term effects we see at Para 2 has lasted for at least 12 months. Likely
Pause
to
a
last for
second.
at least 12
Pause a
months.
second. I'm working, just so you understand, I'm working off an electronic bundle.
Understood.
Which is a numbered electronic bundle. And I was ever in hope that I was going to be given page numbers to move between, but I can get over that if I'm given
My apologies for that.
time. Right. Can you give me any pointer in terms of what's in the Westlaw page number?
So the Westlaw page, top page, is 194.
Yes.
471, I'm told.
470. Thank you. 470 it starts at, and we're talking about here determination of disability,
That's
impairment. And now
Yes.
on to which paragraph?
So 2 deals with long-term effects,
Yes.
likely to last for at least 12 months, likely to recur. 5 addresses the effects of medical treatment, which must be discounted if, but for that treatment, the condition would be likely to have those effects, either substantial adverse effects. And then if we follow to 2 pages along from that, just at the bottom of the page, Part 2 guidance. Para 12, over the page again. Adjudicating bodies. In determining whether a person is a disabled person, an adjudicating body must take into account of such guidance as it thinks is relevant. An adjudicating body is a court, a tribunal, or a person other than a court or tribunal who may decide a claim relating to a contravention. May decide that the guidance doesn't fit the particular facts, must take account of it.
First, you have to decide if it's relevant. If it is relevant, you must take account of it, and you'll give it such weight as you think appropriate
Quite.
in the facts of the case.
Right. The decision, if a conscious decision were made that it was not relevant,
Yes.
one would expect that to be found in the judgment. The reason for discounting the very provisions which deal, or the very guidance which deals with when an effect is substantial, when it's likely to recur, etc., etc. That's the purpose of the provision. I'm sorry to jump around this section, particularly given that it's not paginated, but I was then taking you back to Part 1 and the prohibitions of different guises of discrimination. Direct discrimination. A person discriminates against another if because of that protected characteristic, A treats B less favourably. And for present purposes, Section 15, the Westlaw page at the top right-hand corner is 14. A person discriminates against a disabled person if A treats B unfavourably because of something arising in consequence of B's disability, cannot show that the treatment is a proportionate means of achieving a legitimate aim. And for the knowledge ground, I'll flag this now, subsection 1 does not apply if A, i.e. the employer, shows that A did not know and could not reasonably have been expected to know that B had the disability. So that's the knowledge component. Section 19 over the page.
Just to be clear,
Yes.
subsection 2, is this right, only matters if you've got through the gateway of subsection 1?
Quite. Yes.
So if, and I know you dispute this, but if this employment tribunal was entitled to make the finding of fact, which it did, on that question of whether this appellant had a disability, then what they said about knowledge doesn't matter.
Absolutely. And this is, it's an important point, and one that's obvious, but it's important all the same. Disability is a threshold condition. If the claimant isn't disabled, that's the end of it. There's no legal duty to do any of the things that he was asking the tribunal or his employer to do. And that's precisely why it must not be set too high. And the suite of authority is about, and the trajectory of the Equality Act, which I'll take you to in due course, is precisely about not setting that bar too high. Substantial means more than minor or trivial. Likely means could well happen, real possibility. And the problem with the approach of the tribunal, despite the best efforts to rectify by the EAT, we say rectify a flawed decision, is that it erred in its legal approach. And that's why there's no perversity ground here.
Sorry,
That's why there's no perversity ground squarely before the grounds of appeal. This decision reflects a series of errors in legal approach.
Yes. Even though they self-directed themselves expressly by reference to the House of Lords decision, which says that likely means could well happen.
This would not be the first occasion, in fact there are 4 before you in the bundle, of an impeccable self-direction falling foul when it comes to applying that self-direction to the facts. And that's what happened here. Right. And of course Boyle only addresses the likelihood of recurrence point. There is no authority at all in a judgment of 192 paragraphs on what's meant by substantial adverse effect, and the correct legal approach to determining that point. And then forgive me, indirect discrimination, section 19. There's no knowledge requirement there at all. If there's a provision that causes particular disadvantage, in fact, there's not even a causal requirement. If there's a substantial disadvantage to a protected class, then there's indirect discrimination absent of justification defence. And then finally, the duty to make adjustments requires, at section 20, the claimant to establish a PCP or an arrangement in the workplace which causes particular disadvantage, knowledge of the actual constructive knowledge of the disability and the disadvantage, and the identification of some measure of reasonable step. That's the structure of the Act. I want to make 4 broad points, 3 on disability, 1 on reasons, before turning to the grounds. Firstly, I've said it before, and I'll repeat it. The questions of disability and knowledge are threshold conditions. They are no more than a passport. They say little of the destination. Take the claims here. If you're with me that this tribunal erred in its approach to disability and knowledge, doesn't mean for a moment the claimant succeeds. Section 15 and Section 20, discrimination arising in consequence of disability and reasonable adjustments. He must establish that there is on Section 15 first, that there is a causal link between the something arising that he says and the condition, and it's open to the employer to justify any such step. The claimant says here, you dismissed me because I was on a period of sickness absence. Has to establish a causal link between the sickness absence and the disability, and open to the employer to establish justification. Reasonable adjustments. What is known, what is reasonable. These threshold conditions are then couched in questions of causation, reasonableness, and justification, which is precisely why the authorities all speak with one voice, which is that it is imperative not to set the bar too high.
Now, you said you had 4 points here. The first was
This is the first.
a threshold. Are we still on the first?
I'm still on the first.
Right, threshold.
Threshold.
Don't set bar too high.
That's one. Threshold. Don't set the bar too high. I'll tell you what they are, and then I'll
Thank you.
expand upon them. Secondly, the need for a purposive and social model of disability, reflected in EAT authority and elsewhere. Thirdly, the particular difficulties
Purposive and social model
of disability. I'll give you the labels and I'll provide the substance in a moment. Thirdly, the need for particular caution in mental health conditions, cases of mental health conditions. And finally, the question of reasons, what I'll call the ANYA question or the ANYA issue. Going back to threshold conditions, can I take you to SCA Packaging and Boyle, which is at tab 8. I'll return to what Boyle says on the likely question in a moment. But before we get there, there's some important observations from the then House of Lords as to why there must be a workable approach to these threshold conditions. And it starts at Baroness Hale's judgment at 68. And a citation of Lord Nichols in Re H.
page number?
I have tab 8, paragraph 68. 100. Thank you. Starts with a citation of Lord Nichols and Re-Age.
What are you citing this for? What likely means?
I'm citing it for the correct approach to these questions being threshold conditions, and precisely why it is important the bar is not set too high.
Right.
Paragraph 68, Baroness Hale cites Lord Nichols, dealing with a context which at first blush is different, but Baroness Hale says similar principles apply. The context there, the degree of likelihood of harm, shows that likely is being used in the sense of a real possibility.
Yes, I mean, I think that these are quite basic concepts, aren't they? I mean, I think we can move to, is there anything distinctive in this case that bears particularly on this case? We understand may well as being the test rather than more likely than not.
Well, what I wanted to take you to, my lord, is what's said at paragraph 71.
Thank you.
Having identified this this point of likely being a real possibility. The employer needs to know this in real time and not to have to wait until the tribunal has heard all the evidence and reached a conclusion about what is more likely than not to happen in the future. Bottom of page 1076. As with the childcare cases, the question here should be, are these adverse effects sufficiently likely to require us to consider what, if any, adjustments should be made to take account of them? And then at the bottom of the page begins Lord Brown's judgment. And if I could ask you to turn the page again to paragraph 77 of that judgment. If someone is a disabled person within the meaning of the Disability Discrimination Act, others must, in certain defined circumstances, make reasonable adjustments in relation to him. If not disabled, however, the person could look to no such consideration. And the conclusion of that paragraph, if, however, she was not to be regarded as disabled, her employers would be free of these constraints, i.e. free of the duty to make reasonable adjustments. And so that leads Lord Brown to observe that unless the risk can be shown, this is following paragraph just below E, is it really to be said that unless the risk can be shown to amount actually to a probability, the employer, subject only to ordinary employment law considerations, can simply ignore the employee's condition and take no steps whatever, however ostensibly reasonable, to accommodate the employee's need to continue the treatment measures? Such, to my mind, plainly not. It's sufficient to establish that were the treatment regime to be materially disrupted, the severe disabling effects could well recur. Such a finding would carry with it a requirement of cooperation on the employer's part. So much for the substantive issue for decision. The reason I cite that is because central in the analysis of the House of Lords is a recognition that unless the threshold condition is met, there's no legal duty at all. The effect of this decision is that an individual who moulds their life around a paranoid persecutory delusion is to be treated just as any other employee. There's no obligation to treat that individual differently, notwithstanding the effects of that condition on the individual.
I'm sorry, I'm obviously being very slow. Surely, although as you have described it, it's a threshold question, the answer to it is going to depend on the facts of a particular case. Speaking for myself, I just don't see any general point of principle emerging from that at all. That is a totally unsurprising position to find oneself in. That's why we have tribunals. They determine questions of fact, including what you've described as a threshold question. The answer to it may be yes, the answer to it may be no. There's nothing surprising about that. It doesn't lead to any general implications for other cases.
Well, the implication, my lord, is really this, and we'll see this in the law on what's meant by substantial. The whole purpose of the disability provisions is to impose a legal duty where reasonable, where the alternative cannot be justified,
Yes.
to remove barriers which hinder participation in the workplace.
There may not, in fact, be barriers. Lots of people who have a disability, for all sorts of reasons, such as privacy, such as pride, they are perfectly capable of carrying on and doing what their colleagues are doing. So, as you say, there's a threshold question. There will be some cases in which somebody has a disability in accordance with the statutory definition. It doesn't mean that everyone will. So the question for a tribunal is always going to be, did this particular claimant have it at the material time? They asked themselves that question and they answered it no, on the evidence that they'd heard over 9 days.
Well,
you're entitled to complain about their reasoning process and so on, and of course we'll look at all of those specific grounds of complaint. I'm just not understanding at the moment why this case is thought to be about some general principle. Surely it's just a case on its own particular facts, important though they are to the parties.
well, because if the approach to substantial adverse effect adopted in this case were the correct one, i.e. look to what individuals see at the material time, look to the fact that the claimant may well have over-egged the pudding on one particular point on personal hygiene, etc., rather than what are the effects, are they more than minor, are they minor or trivial? If they're not, this is a disabling condition, which is the approach that's been adopted up to this up to this decision. There are real problems with that, particularly in the context of mental health cases.
Right.
I'll whistle stop through the other four points. I made the issue. I've raised the issue on purposive or social model of disability. Can I take you to tab 6? In case of Patterson, decision of the then president of the EAT, it's Justice Elias. The first point that's made here is that when it comes to assessing substantial adverse effect, the tribunal must adopt a comparative exercise between the position of the individual without the impairment, without the effects of the impairment, and the individual with those effects. And if the difference in comparison is in effects, the ability to participate in the workplace is more than minor or trivial, then the tribunal must conclude that an individual is disabled. Can I flag for now, I'm conscious of time, but the point that I make on threshold conditions, paragraphs 33 to 38 of Mr. Justice Elias's decision, in which Mr. Lowdy reasoned that the conclusion of the trial...
Do you want us to look at 33 to 38?
33 to 38.
Thank you. Give us a moment. Right, so what does that bring to this case?
Well, I was citing that for the purposes of the threshold condition point I make, which is that what those paragraphs invite is taking a step back and considering, really, is this an individual to whom the legal duty is owed?
Yes, well, in this case,
remove barriers in the workplace.
From what I've read of it, you've got somebody who needs 25% more time to perform their ordinary duties.
Yes.
As a result of dyslexia, and the tribunal said, well,
to perform exams. Yeah.
Right. Well, the promotion assessment needed 25% more time.
Yes.
That, they say, is, my words, not that self-evidently a disability.
And the final point I wanted to make on Patterson, 67 to 68, as to what's meant by day-to-day activities, must encompass the activities which are relevant to participation in professional life. Appropriate measures must be taken to enable a worker to advance his or her employment. Since the effect of the disability may adversely affect promotion prospects, then it must be said to hinder participation in professional life. That reflects the approach taken by the UN Convention on Disability. In other words, if there's a step which hinders participation in working life, or if there are effects which hinder participation in working life, then they are to be regarded as disabling. That's what I mean by the social model, rather than necessarily a medical model of disability. Thirdly, mental health conditions. It's particularly important, I submit, not to set the bar too high, whether on definition or knowledge, in the context of mental health conditions. They are often more susceptible to fluctuations, as observed in the contemporaneous notes of Dr. Watson. There are efforts which an individual may take to conceal or suppress the effects of a mental health impairment due to stigma. Quite often they lack a definite prognosis and are more liable to be exacerbated by external stresses. And as observed in the jointly instructed medical expert here, lay individuals are rarely well placed to gauge mental health. An over-focus on the outward manifestations or the perceptions of others risks imposing a serial model of self-reporting not expected in physical impairments, and thwarting the purpose of the legislation in that it relies upon a level of insight which the individual may lack, precisely because of the effects of the impairment. Now, take that here. The claimant believed, and on the tribunal's conclusions, still believed, at the point of the hearing, that the delusion was real. And yet, a factor which the tribunal seems to take into account, paragraph 98 of its judgment, is that the failure to continually report the delusion should be considered when asking whether there is a substantial adverse effect. The correct approach remains that set out in Goodwin in the Patent Office, recently considered by the EAT in Elliott, tab 22. Picking up at paragraph 17 of that judgment.
I have it, thank you.
You have it. The four conditions which then President Morrison set out in Goodwin. The impairment condition.
Sorry, which paragraph?
Paragraph 17. Thank you. The impairment condition. Does the applicant have an impairment which is either mental or physical? The adverse effect condition. The substantial condition is the adverse effect substantial, and the long-term condition is the effect long-term. And as President Morrison observed there, echoed by the EAT and Elliott, tribunals may well find it helpful to address each of the questions, but at the same time be aware of the risk that disaggregation should not take one's eye of the whole picture. Take a step back, and does this feel in keeping with the legislation? Paragraph 20, this is Justice Morrison, cited again by the EAT. Tribunal proceedings have an inquisitorial element. The tribunal should bear in mind that with social legislation of this kind, a purposive approach to construction should be adopted. The language should be construed in a way which gives effect to the stated or presumed intention of Parliament, but with due regard to the ordinary and natural meaning of the words in question. So it's imperative to focus not upon what the individual cannot do or only do with difficulty. Forgive me, it's imperative to focus on what the individual cannot do or can do only with difficulty, i.e. how daily activity is performed, rather than the things that the person can do. And as the EAT observed in Eliot, it's difficult to do that if you don't first begin by identifying what the effects are. At paragraphs 72 to 73. Where coping strategies are engaged, such as they were here, regard must be had to whether those coping strategies may fail under stress. Paragraphs 59 to 61 of Eliot. The fact that somebody carries out certain activities does not mean that they experience more than minor or trivial adverse effect when doing so. And the fourth overarching point that I wanted to make was one of reasons. Goodwin and reiterated by Eliot set out what the reasons must cover, those four tests. And it's imperative upon a tribunal not only to identify the conclusions, but how those conclusions are reached. I set out the applicable guidance of Anya and Tran at paragraphs 39 to 41 of my submissions. In view of time, that the authorities are found at tab 3 and 4. But in view of time, can I just flag para 69 of Lord Justice Sedley's judgment in Anya, my paragraph 41.
Sorry, is that tab 3?
That's tab 3, para 69. If you have my submissions down, it's paragraph 41, but I'm happy to look at it in either version. Forgive me, 20. I don't quite know where 69 came from. 26. Sideline passage 26. The courts have repeatedly told appellants that it is not acceptable to comb through a set of reasons for hints of error and fragments of mistake, and to try to assemble these into a case for oversetting the decision. No more is it acceptable to comb through a patently deficient decision for signs of the missing elements, and to try and amplify these by argument into an adequate set of reasons. Just as the courts will not interfere with a decision, whatever its incidental flaws, which is covered up the correct ground and answered the right questions, so they should not uphold a decision which has failed in this basic test, whatever its other virtues. It is not for the appellant tribunal to fill the blanks that the tribunal below has left.
You cited Eliot to us.
Yes.
Okay, that's a subsequent decision to the ones with which we're concerned here.
Eliot reached you on Friday.
No, I'm just observing that Eliot is a recent decision.
Yes, it is.
From this April. I appreciate you say it builds on Goodwin, but it wasn't itself available.
Wasn't itself available,
No? Okay.
and sets out, we say, some important points on the correct approach.
So, Mr. Milsom, is your submission that this is a patently deficient decision of the type to which Lord Justice Sedley was referring in paragraph 69 of Anya?
Just as the threshold of disability must not be set too high, so too the adequacy of reasons threshold. I don't have to establish that it's patently deficient. What I do have to establish is that it's inadequate.
Well, I'm just asking you whether that's your submission or not. perhaps just focus on the question I've asked you, please?
My lady, I say it is
Right.
on the critical questions before the tribunal. At the very least, it's inadequate in its reasoning.
Could you just list, I mean, I'm not putting you to the test here, but just to understand what lies behind it, you say, what are the critical questions that the decision is patently deficient?
The critical questions are those set out in Goodwin, reiterated by Eliot. Impairment.
Well, no, just tell me a question what is something with a question mark at the end that the decision does not cover that it must have done?
What are the adverse effects?
Yes?
Are they more than minor or trivial?
Yep.
Is there a real possibility that those effects will continue for 12 months? Is there a real possibility that they will recur? And as I say, bare conclusions in respect of each of those are not sufficient. What Anya and Tran remind us is the how is just as important as the what.
Do you care to distinguish between those four questions? Understand all of them now. As to whether the tribunal addressed them at all, addressed them adequately, or addressed them inadequately?
Well, the tribunal reached conclusions in respect of each of those points.
Right. So the tribunal, at the lowest level, addressed each of those questions?
Yes.
So what do you say? Are you just saying that it's the same in relation to all of them, or are there any that you're particularly concerned about?
Well, they are the two grounds, essentially, of substantial adverse effect ground 1 and recurrence and likely duration ground 2.
So of the
that's where I'm turning.
Of the four, it's the first and the fourth that you gave us that your grounds of appeal are focused on.
Well, 1 and 2. Forgive me if I can add to the list of questions on the knowledge ground.
Yes.
What did the employer actually know?
Yes.
What steps ought they reasonably to have taken to find out more? And had they taken those steps, what could they reasonably have concluded?
So as you come, no doubt, soon to your grounds of appeal, you'll identify the extent to which you say they did or didn't do a proper job in relation to those questions.
Yes. Substantial adverse effect. As His Honour Judge Taylor observes at paragraph 27 in Eliot, more than minor or trivial is no longer a matter of the code, but it is on the face of the statute, section 212.6 of the Equality Act.
Section 200.
212.6 of the Equality Act.
Is that in our bundle of authority?
Yes, please.
I didn't see it.
I believe it is.
If don't take time now, but if it's not, can you make sure that it's sent through
Yes.
to us?
Yes. And a case in the decision of a further EAT president, there is a common theme of EAT presidents on disability cases, Adarami, which was before both the Tribunal and the EAT. Mr. Justice Langstaff identified the correct approach to assessing whether an effect was substantial. That's tab 11.
Yes, more than minor or trivial.
Well, it goes a little further, the Act did not create a sliding... I'm looking at the head note for now.
Yes.
The Act did not create a sliding scale between matters which were clearly of substantial effect and those which were clearly trivial, but provided that unless an effect could be classified as trivial or insubstantial, it was necessarily substantial. That the Tribunal had failed to use a comparative approach to look at what the claimant could not do because of his disability compared with that which what he could do.
So which paragraph are you...
I'm looking at the head note.
Oh, sorry. Yeah, thank you very much. Yeah, I read this, and I don't mean any disrespect to the then president of the EAT, but surely there is a spectrum. These seem inherently to be questions of fact and degree. I certainly accept that the legislation is binary.
Yes.
So once you're through the gate, once you're over the threshold, to use your metaphor, then you're in.
Yes.
It doesn't matter if you've got over the bar by 10 meters or 1 meter. It doesn't matter. You're over the bar. That's what matters.
You don't have to pass it or saw it.
No, but surely, actually, the assessment may well be one of fact and degree. So it may be that you fall short of it by a meter, or you fall short of it by 10 meters. Why isn't there a spectrum?
Well, the only spectrum is it minor or trivial? That is, if it is truly minor or trivial, then you don't meet the threshold.
No, I understand.
And
So what's the answer to my question? Do you accept that actually the assessment which the fact-finding tribunal has to make may well be one which is a question of fact and degree?
Well, there has to be some measure of factual evaluation as to whether something is minor or trivial. Of course there does.
Yeah.
I mean, the analogy that I've been thinking through is seismologists may disagree whether there's a Richter scale of reading of 4 or 7. Provided it's 1, that's sufficient. Now, there may be a spectrum of evaluation between 0.5 and 0.7, but if it's 1, that's enough.
Yeah, exactly.
And the point of the legislative framework is that there are control mechanisms when it comes to the liability stage: justification, causation, reasonableness. And that's precisely why the more or the minor or trivial has not only been recognised in the code, but now amplified to a statutory requirement. And what Mr. Justice Langstaff reminds us at paragraph 14 of the judgment in Adequacy is once it's been established that there is an effect on daily activity, the tribunal must then assess whether that is or is not substantial. However, it has to bear in mind that the Act does not in itself create a spectrum running smoothly from those matters which are clearly of substantial effect to those matters which are clearly trivial, but provides for a bifurcation. Unless a matter can be classified as within the heading trivial or insubstantial, it must be treated as substantial. You can't begin to undertake that task until you work out what the effects are, then compare the pre-effects position to the post-effects position. And if the effects are no more than minor or trivial, the claimant's not disabled. But that requires a comparative exercise, and the failure to undertake that approach is a failure of legal approach.
Now, can you just help us as to where we're going
Yes.
with this? Because I mean, many of these propositions seem to me, with respect, to be pretty basic. I know you're going to say they were forgotten, but that calls for us to look at the decision of, amongst others, this president, rather than a large number of other presidents.
Yes.
So, where have you got to in terms of your?
Well, I'm dealing with
map?
I'm dealing with ground 1. Adequacy is the correct approach. I then want to take you to the material which was before the
Right, so
tribunal.
ground 1 is substantial adverse effect.
Yes.
At that point, this is where you started on that.
Yes.
Yes. Right.
The material before the tribunal had an impact statement from the claimant. which set out we've got that statement, paragraph 9 onwards, pages 9 onwards to 9 to 25 of the supplemental bundle, in which examples were given of delays in leaving the house, changing travel and eating plans, repeatedly changing his phone and password, inhibitions on communication.
Do you want to just give us the page
Yes.
or paragraph reference? And then
Yes. So 18 to 19. Claimant describes being convinced that there was a break-in and installing cameras into his home.
right, we're looking here, are we, for a substantial adverse effect, properly so understood, upon the performance of his day-to-day duties?
2 questions. What are the effects? Are they more than minor or trivial?
Yes. So now, where are we getting to his work?
Well, if I can take you to... There's various examples in the preamble but of the statement. If we look at paragraph 33, the statement gives 25 examples of effects on his daily activities.
Personal and domestic life.
Personal, domestic, and work.
I'm looking at paragraph 33.
He deals with admin. He deals with social effects. He deals with social media, spending time alone. Erratic sleep.
I understand that, and I don't minimise this. It's a distressing picture. But can you please help us by focusing on what the statute calls for, which is to consider the impact of all of this upon his work?
The statute does not call for focus on work at the definition stage. The statute simply asks, what are the effects, and are they more than minor or trivial? The claimant listed 25. There are several other examples in the judgment, in the statement. Engagement with work communications, engagement with his work phone, putting false entries on his Outlook calendar because he feared that individuals were following him. And they are also dealt with by Dr. Watson, whose notes we see at pages 1 to 2. And then we have the report at page 6. And at page 6, she is describing what she observed 3 years before any claim was presented to the tribunal. Clearly presented, the bottom paragraph, clearly presented with symptoms of significant stress, anxiety and depression, disturbed sleep, drinking excessively in the evenings, having problems getting up on time in the mornings, and difficulties in leaving the house to get to work on time 5:30 every day. Due in part to tiredness from lack of sleep, but also due to the fear he would be watched and potentially approached by gang members. He'd isolated himself socially due to his anxiety about being out in public, and also due to his difficulty in using any technology, including telephones and computers, as again he was suspicious that his activity was being monitored. It made it difficult for him to carry out his duties at work, such as using the telephone and updating his work calendar, experiencing feelings of isolation, etc. And then over the page, diagnosis of a stress-induced major depressive episode, certainly consistent with that, she concludes. Symptoms made day-to-day functioning very difficult for Mr. Sullivan, as it made it hard for him to focus at work, attend meetings, communicate effectively, or process information. This is at a point...
What period are we talking about?
Right. This is at a point in 2014. This is outside the 2 flare-ups. This is at a point where the tribunal concludes that there were no substantial adverse effects on daily activity. And then we have the jointly instructed expert,
Sorry, before you go to that, did the tribunal make reference to Dr. Watson's report?
No, none. I take my lady's point, question of weight, given that Dr. Watson was not there, but to not refer to it at all is respectfully perplexing.
Well, we have somewhere the history of your client's presence, absence from work and his earnings during this period, over the 4 or 5 years.
There'll be a schedule of loss somewhere, I believe.
Yes.
Yes.
There is. So, I mean, when considering this sort of information, I mean, do we know what, there's a letter of instruction, do we know whether Dr. Watson knew what your client was doing, what he was earning, where he was going, how he was performing his duties, or is this self-report?
As with any other mental health condition, my lord, this is self-reporting.
Yes.
Yes. But as I say, so too with almost any scenario of assessing a mental health condition. Outward manifestations can only go so far. And then we have the jointly instructed expert, whose report, by the very nature of things, was retrospective, but nonetheless based upon Dr. Watson's report and other material. And we see that it starts at page 26. Dr. Wise rules out faking it or fabrications, concludes that there's a good effort to engage. And then the substance of it, page 39, paragraph 40. Mr. Sullivan is a middle-aged male who before 2000.
All right, do you want us to read
Yes,
paragraph
please.
40? Anything else?
40, 41, 44. And then the summary at page 42.
Thank you.
What does Dr. Wise mean by the expression more than a season? I think I've seen that used before.
I mean, there are certain phrases which I've not come across, but I think what Dr. Wise is driving at is that this is a persistent underlying condition rather than something which ebbs and flows.
I took it to mean that there might be a few months of respite.
Yes.
Otherwise, it was, as you say,
Yes.
continue.
Yes. And to save returning to this on the question of likely duration or recurrence, I would just flag at the end of paragraph 57. Whilst the condition has ameliorated, more prolonged interventions are required for a good prognosis.
Paragraph 55 may be important, because he expresses himself in the conditional. If the tribunal accepts, etc.
Yes.
They didn't. Ultimately, they
Well,
made an assessment. Having regard to duration. I don't think they were belittling. No one, I think, would wish to, but as my lord has said, it's distressing. But they had to form a judgment, ultimately, about the likely duration. Because it's not any... Just because you get over the threshold of minor or trivial impairment doesn't mean that you're within the statutory meaning of disabled.
forgive me, Millard, I'm not sure if that's what paragraph 55 is driving at.
No, it may not be.
But forgive me, as I understand paragraph 55, it is an appropriate example of an expert avoiding legal conclusion.
Fine.
What Dr. Wise does is set out what the effects are, accepts that it's for the tribunal to determine whether those effects are minor or trivial.
Yes.
And if they're not minor or trivial, then there is a consistent underlying condition with those effects for the entire period.
Yeah.
But from the tribunal's perspective, what it had to do is first identify what the effects were.
I understand.
And if it didn't accept the effects as set out in the joint medical expert and the contemporaneous medical expert, why not?
All I was getting at is that one ground of complaint, which may or may not be in the grounds of appeal, let's park that for now, is that they impermissibly departed from the finding or opinion of the jointly instructed expert. But I'm just putting to you that they may not have departed from it at all. They were simply accepting, as it were, his invitation to make their assessment. And he says, if you accept this, then this consequence follows.
Well, if these factual conclusions as to the condition satisfy the legal definition of minor or trivial, or more than minor or trivial, then the claimant is not disabled. That is the correct reading of paragraph 55. The complaint is to the as to the treatment of the medical reports is that in the case of Dr. Watson doesn't address it at all. In the case of Dr. Wise, doesn't reach the findings as to what the effects were, departs from the conclusions as to Dr. Wise as to what the effects were, and having failed to do that, can't begin to do its legal duty, its legal obligation to identify whether those effects are minor or trivial. That's the problem.
We are concerned here, aren't we, with the outward manifestation of a condition. That the statute requires consideration of ability to carry out normal day-to-day activities. Of course, there are many things that would feed into one's ability to carry out normal day-to-day activities, but one's not concerned, at least the statutory test is not concerned with what is within one's thoughts.
It is.
Well,
Okay,
you'll take me to this and that's it.
Yes.
The ability to carry out one's normal day-to-day activities, which Dr. Wise is addressing himself to, might be thought rightly. Of course, there may be many reasons of a disability nature why one would not be able to do that, and provided you get over the minor trivial threshold, you've got that far. But do you want to, at some stage, either now or later, explain why it's not an external activity test?
Well, what the tribunal has to consider post Goodwin and reaffirmed by Elliot is what, in fact, this individual experienced when carrying out day-to-day activity. How they, even if they did it.
Yes, you have to compare what their performance would have been with or without.
And if the differential is
the condition, but in the end, what one's concerned with is what they did or did not do.
Yes.
It's not what they thought or did not think, what they felt or did not feel.
That much I would go along with the important qualifier, as in Goodwin and Elliot. The fact that somebody is able to complete a day of work in and of itself even if nobody detected an issue, in and of itself is not the full answer to the question. If the
No, I understand that. I wasn't suggesting it was.
No, but if the way in which they undertook that work, even if it was guided by internal coping strategies, was blighted by effects which were more than minor or trivial.
But it's the way they perform their activity.
It's what they cannot do or can only do with more than minor or trivial difficulty. And the knowledge question, what the employer thought, what the employer witnessed, is a different question, particularly in the context of mental health conditions, which are very often hidden and concealed. The tribunal cannot begin to undertake its task on substantial adverse effects without looking at reaching findings of fact as to what the effects were. Just finally, I'm conscious of time, on Dr. Wise. Further questions were put to Dr. Wise, presumably by the respondent. We see the answers to those at paragraph 52, page 52.
Paragraph?
At the bottom of the page on answers.
Yes.
Rather goes to the point that I was making, my lord. Many mental health disorders are difficult for non-specialists to identify, let alone lay people. Whilst the answers to the Paula's disability scale indicate that Mr. Sullivan would be more likely than the average individual to present himself as functional and performing well than the normal individual, that is not what would have made it hard for a lay individual to have spotted an illness, although it may have contributed. In other words, somebody may in the outside world be functioning perfectly well, but lay people are not entirely equipped to address whether somebody is having a mental health condition. And then,
what are they supposed to do in practice? I mean, don't we have to try and apply this legislation in a way that is actually workable in the real world? What's the employer supposed to do? If they're criticised for not spotting something that an expert would have spotted, well, then they're criticised for not responding to that.
Well, the irony, of course, in this case is that this was very much spotted by the employer.
Well, then I'm not sure why this really matters on the facts of this case.
Well, because we come to what the tribunal made of the material that I've just taken you to. The impact statement, Dr. Watson, Dr. Wyatt. At paragraph 98, page 130.
I'm sorry, which bundle are you in now?
130 of the core bundle.
Yes, thank you. Paragraph 98.
Paragraph 98.
This is what this case is all about, isn't it? Really, and I don't want to be unfair to you at all, Mr. Milsom, because you must make all the submissions that you think you need to make to advance your grounds. But doesn't this case ultimately turn on whether they got it at least adequately right in paragraph 98 or not?
Paragraphs 98 to 102 are the crux
98
on
to
disability.
102. All right, 98
Yes.
to 102. I don't want to curtail your submissions at all. But is this case ultimately about the adequacy of the reasoning of the ET at paragraphs 98 to 102?
That is ultimately what it boils down to. I would accept that.
And what was
No, the only finding
Yeah.
that's made as to the list of 25 effects that the claimant sets out is essentially a concession, 98.3. Contrary to what he said about neglecting personal hygiene, he accepted that he in fact showered every morning. Where that leaves the other 24, the tribunal's conclusions as to the remainder of the impact statement, the remainder of the medical evidence, it is something of a mystery. Because the only other matters which, on which the tribunal relies are self-reporting, i.e. a failure to report in September 2013, and outward manifestation. Now, those questions may be relevant to knowledge, but they are not a complete answer to what the effects are and whether they are more than minor or trivial. Now, it seems that both the ET and the EAT were influenced by two factors. Firstly, that there were difficulties with timekeeping, for example, pre-2013, pre-disability. And secondly, that there may have been an exaggeration of one example withdrawn by concession of the list.
What was that example?
The showering
Oh,
example.
that's the shower point, right. Okay. Right.
But they do not answer the fundamental question. He may have been difficult before. He may have overstated the position during the course of the disability, or the putative disability. But you have to compare what the impact of the effects. You have to compare what this individual was doing before and after.
Well, can we? I mean,
and it's just not there.
It's maybe a red herring, and you can tell me that it is. But if you go supplementary bundle, page 87, we have the figures that I was asking you about earlier on, in which one sees that over the period in question, the claimant was earning extremely substantial amounts, which rose markedly year upon year.
Yes.
To, well, frankly, mythic figures. Doesn't that form part of the picture as to what substantial effect?
Well, firstly, it's not the way the tribunal looks at it. It's simply not a factor that the tribunal relied upon. Secondly,
no, but it's. I mean, the weather to this is of what, on the face of it, seems like paragraph 20 of Mr. Drake's statement. Seems like a burgeoning career.
But one still has to focus upon what the effect of that, what the prospect of that career, what might have happened absent the disability.
And what was the evidence about that? That he would have been earning even more?
Well, with respect, my lord, the earning point wasn't put into issue by either party as a barometer for whether this effect.
No, but I mean,
was
the tribunal will have been aware of the fact that while all this was going on, it wasn't a situation, happily, where your client was not able to continue to work. It was simply a question whether he ought to have been earning even more, I suppose.
Someone may be a multimillionaire and still be disabled. Someone may be a billionaire and still be dyslexic. One has to focus on what is the effect of this condition and compare the flourishing career of an individual that may still be on the upwards trajectory of earnings with what they would have done absent the impairment.
And somebody could be a poor timekeeper, irrespective of their disability.
Quite so.
And isn't that in substance what they said here?
I accept that. But what the tribunal also concluded is that the issues were exacerbated by the condition. At paragraph 97. By 27th of July, Mr. Drake had recorded the claimant's belief about the Russian gang was having a significant effect on him. On the 1st of August 2013, Mr. Drake linked poor attendance and erratic behaviour on the claimant's part to this. That's 5 years into employment. At paragraph 99, in relation to 2017, both of these made reference to 2017 documentation to a deterioration of the claimant's timekeeping and performance and reflecting the tribunal's judgment of deterioration in his mental condition. Now, I, in fairness to the EAT's decision in particular, which seems to place great emphasis on this, I acknowledge that there is enough in the judgment to say that there were some issues with timekeeping beforehand. That can only take you so far, because one has to consider what the effect of the impairment is. And if those issues are exacerbated, as the tribunal found here, there is a more than minor and trivial effect.
That must be implicitly what they have found, isn't it, at 97? Isn't that a complete answer to your ground one with this appeal? They make a finding of fact that there was a substantial adverse effect on the claimant's ability to carry out normal day-to-day activities of sleeping and social interaction.
Yes.
It doesn't the case actually, therefore, turn on the duration point?
Yes, which requires the tribunal to conclude.
That's your ground two.
Well, it's ground one. Ground one is there a substantial adverse effect throughout this period? And the tribunal can't determine that question, and therefore can't apply the correct legal approach without identifying what the effects were throughout and whether they were more than minor or trivial.
They did. At 98, they specifically make a finding of fact that it did not, at this stage, continue beyond September 2013.
And then we look to the reasons.
Exactly.
And the reasons are...
I understand your argument that there's an inadequacy of reasoning.
Yes.
I'm afraid at the moment I do not understand what other error of law you say they have fallen into, because they appear to have asked themselves all the questions that you say they had to ask themselves.
Well, my lord, I've addressed you on the approach to the medical evidence. Point made by the ET and the EAT is that the evaluation of medical evidence is for the tribunal applying the legal test. I acknowledge that.
Yes.
They have to first consider the medical evidence in the first instance. I've given you the example of the Dr. Watson report, which is an important indicator as to what was going on in the interregnum period, and does not make a word in the tribunal.
That I've understood. That's a submission you made to me about 20 minutes ago, and I do understand that point.
I'm conscious of time, so can I give you some references?
Sorry, can I just understand something, Mr. Milson?
Yes.
What does the Watson report add to the notes? Because the notes, the tribunal does refer to the notes, and the notes do deal in part, I think, with that period. But maybe I've got the wrong end of the stick.
The report provides fuller conclusions as to evaluation rather than simply a contemporaneous note. It's Dr. Watson's assessment as to what those notes reflect on daily activity.
But the notes are the foundation of the analysis in the report. Is that right?
Well, the meetings are. The notes are a shorthand of those meetings.
Right. Okay. Thank you.
On approach to medical evidence, so if I can give you this in shorthand, whilst the question of substantiality is a legal test, questions of diagnosis and observations of day-to-day activity and the ease of performing functions and opinion on prognosis are matters where the opinion of medical experts, particularly where they're jointly instructed, must properly be considered if the tribunal is to approach its fact-finding in a permissible way. Tab 2, Abaday, I'm conscious of time, and I don't have time to address you on, take you to each authority, but Abaday, the head note, and paragraph 20. Fathers and pets at home, a decision of then Justice Singh, tab 10, paragraphs 49 and 51.
So which case was that?
Fathers and pets at home.
Yep. The tab?
10, which the point's made that whilst the effects may be overstated in some respects, one still has to go apply the act and work out whether the remaining effects are more than minor or trivial.
Which paragraph was it in my judgment?
It is paragraphs 49 and 51 on the approach to medical evidence.
Thank you.
Elliott and Dorset, tab 22, paragraph 78. And I will take you to this, if I may, just whilst we're on the subject of medical evidence. J and DLA Piper, tab 9. the head note first. At para 2. In which then Mr. Justice Underhill concluded that the failure to take into account evidence from the claimant's GP, written uncontested oral evidence, written evidence not adduced orally, amounted to an error of approach. Had the tribunal taken that evidence into account, it would not necessarily have reached the view that the claimant did not have an impairment, or that even if there was an impairment, it was not substantial long term. And on the question of recurrence and the impact of medical evidence, can I ask you to read paragraph 45 of that judgment? Really, it's 45 from E down.
It doesn't sound like a proposition of law, I'm afraid.
No,
it's simply saying, in a given case, it may be appropriate. It all just comes down to what are the facts of a particular case, doesn't it?
The reason I'm flagging that at this juncture is I'm returning to recurrence, but hoping to avoid you from digging up too many authorities at the same juncture. So you have my point on the approach to the medical evidence. The second point on substantial adverse effect is the tribunal's emphasis on the observations of others. We must consider the logical effects of Mr. Isiaho's evidence.
This is 98.5.
This is 98.5, informed by 41 to 43 of the judgment 118 of the core bundle, in which it said that Mr. Isiaho was present from September 2014, close to the claimant in physical distance, proximity, and 43 did not notice any significant change in the claimant's appearance or behaviour from when he joined the respondent until the claimant's dismissal in September 2017. That was the tribunal's conclusion. And we can see the logical implications of that in the submissions of my learned friend who appeared at first instance. Paragraph 81 of the core bundle, page 226. Sorry, supplementary bundle.
So supplementary page
226, paragraph 81. Letter B. In which my learned friend is addressing the tribunal on the position in April 17. If the claimant's ability to carry out normal day-to-day activities had declined in the manner described, Mr. Isiaho would have seen this. And for that reason, the respondent said that there was no substantial adverse effect in April 17. The problem, of course, is the tribunal concluded that there was a substantial adverse effect from April 17.
But to be fair to Mr. Lee, the introductory paragraph of 81 says the objective evidence of this is again slender.
Yes.
This is a paragraph dealing with objective evidence, and if one that feeds into what the tribunal say in 98.5 of their decision, where they say the tribunal would have expected him to have noticed such an effect had it been there to be observed. So what they're looking at is what objective evidence supports the subjective effects which the claimant is reporting, aren't they?
That much I accept.
And isn't the objective evidence relevant to their assessment?
It is a feature.
Right.
But there is a logical contradiction which the submissions at first instance reflect. If the barometer as to whether the effects are substantial is the perceptions of others, and yet the tribunal simultaneously recognises they do not tell the complete picture because there was a substantial adverse effect from April 17 onwards, then there's a problem. And it's a problem that is not answered in the judgment.
But the tribunal aren't treating the objective evidence as the only factor. This is the conclusion I might draw from that.
In which case, Madam, I ask somewhat rhetorically perhaps, what are they looking at? We have at paragraph 98 three factors, it seems. An exaggeration of one effect, self-reporting the observations of others. What is conspicuous by its absence is that which was required on authority taken, to which the tribunal was taken, i.e., what are the effects, and on a comparative exercise, pre and post effects, is the impact more than minor or trivial? And it's just not there.
Well, I mean, testing your submission, what effect were they bound to find? Were there in the other than at the two periods of intensity? What were they overlooking?
I can do no better than the conclusions of the joint medical expert. Disturbed sleep, reduced activity, social activity, reduced presence on social media, the diminished attendance to mail and email, and the erratic attendance and timekeeping, which was observed by the employer at various stages. I mean, this is one of those instances where, having regard, and this is why I took you, my lady, my lords, to the purposive approach that must be taken to the Disability Act, the disability discrimination provisions. Take a step back. Somebody who has moulded their life in their engagement with the wider world, in their engagement with their employer, and at home, around a delusion, a persecutory delusion. And yet the tribunal's conclusion, without exploring in any real detail the effects that were put forward by the claimant and by the medical material, has concluded that that had no more than minor or trivial effect for 3 years of that persistent delusion, notwithstanding the fact the claimant was recommended to see a psychologist during the course of that period.
This does sound, to me, like a perversity challenge.
Well,
what it seems to be saying is, no matter how well they had reasoned, paragraphs 98 to 102, they came to a conclusion which they could not reasonably have come to on the evidence before them.
Well, my lord, I say it's an error of reasoning and an error of legal approach, because had the tribunal done that which it was required to do, following Goodwin, Adarami, and Dorset County Council, identified the effects, asked whether they were more than minor or trivial. Had it done that, I say it could have only reached one conclusion.
Yeah, exactly.
But it doesn't. But that's a disposal point. It doesn't do that. It just doesn't do it.
Can we look at 95, which is the page before?
Yes.
There, the tribunal summarises the matters that you've been taking us to.
Yes.
So that summary is of not only his written impact statement, but of the evidence that they heard from him. The adverse effects on day-to-day activities of sleeping and engaging in social interaction applied from May 2013 onwards and with some help from Miss Watson in 2014. He remained anxious about the gang and his employer's intentions towards him, and things took a substantial turn for the worse in April 2017 when his package came up for discussion.
Yeah.
So it's not as if, I mean, that was the case that they were considering. It's not as if they didn't hold it up
No, but
to consider it. But your case, it essentially is not that they might have found that to be a disability, but they were bound to find it to be a disability.
It is difficult to see how a properly directed tribunal, properly applying the test which it had to, could have concluded otherwise.
Right. So what is in paragraph 95, which they clearly seem to have accepted that description?
Well, that's the question, my lord. Did they? Paragraph 95 sets out the case.
Yes. Well, they don't make findings that he wasn't anxious about the gang. They don't make findings he wasn't anxious about his employer's intentions towards him. But it's not that they're disparaging what he said. They're describing it. And your ultimate submission, it seems to me, to us, is that perception of the situation is one that was bound to lead them to find that he was he had the benefit of the Equality Act.
Yes, well, yes, that is my submission, which is why I make the points on disposal that I do. But and if I have to meet the perversity threshold, then I say it's met. But the fundamental challenge that I raise, my lord, is that the legal approach just is not there. And the reasons are not there which would support the application of the correct legal approach. Finally, on this guidance, I've taken you to the statutory obligation to take into account the guidance. It does not feature at all. The point made by the EAT is that it may be open to the tribunal to depart from the guidance. Of course it might, but it has to take it into account. We see it at tab 28.
Sorry, tab 28.
Tab 28.
Of what?
Of the authorities bundle. And at the conclusion of that, the appendix, internal numbering of that document, page 53, if you have it. The appendix, either my name was. Yes. An illustrative, non-exhaustive list of factors in which, if they are experienced by a person, it would be reasonable to regard as having a substantial adverse effect on normal day-to-day activities. In the following examples, the effect described should be thought of as if it were the only effect of the impairment. Page 55. Frequent confused behaviour, intrusive thoughts, feelings of being controlled, or delusions. And, of course, the one thing that was clear from the jointly instructed medical expert is that this was a clinical psychotic disorder. There may be debate as to the precise label to be attached to that order, this disorder. Paranoid delusional disorder is suggested by that expert. But there is a reason why a delusion, a persistent persecutory delusion, is in the face of the guidance to be regarded as having a substantial adverse effect.
sorry, I'm not following this submission. You accept that the ET had before it, and indeed referred to, the evidence of Dr. Wise,
Yes.
which referred to the appellant's delusion.
Yes.
But you're saying that they failed to take into account this guidance, which gives as an example that you may want to take into account the fact that somebody has delusions.
Well, this appendix identifies effects which, in and of themselves, it would be reasonable to regard as having a substantial adverse effect.
They did.
Well, but
in two relevant periods, the ET actually did make a finding of fact. What was fatal to the case for you was that it wasn't of a sufficient duration. So it's not the effects that they've ignored. You say, I think you have to say that they couldn't reasonably have come to the conclusion which they did about the duration.
Well, my lord, the tribunal accept that the delusion lasts 4 years.
Yes, they don't accept that the effects last 4 years.
No, the delusion is the effect, according to the guidance. The guidance recognises, in the following examples, the effect should be thought of as having as if it were the only effect of the impairment.
Well, I'm afraid I just regard that as wrong in law then, if that's what it's really saying. Suppose somebody believes that the Earth is flat. Are you saying that that delusion is the effect of their impairment?
Well,
as opposed to, what effect does that have on their day-to-day activities?
the guidance is laid before Parliament. It has to be considered. It may be subject to departure. It has to at least be considered. The guidance identifies a delusion as an effect which may have which is reasonable to regard as having a substantial adverse effect. Now, of course, it depends what the delusion is. It might depend on what the delusion is. Mr. Justice Choudhury postulates the possibility of an entirely benign delusion.
Yes.
This was a persecutory delusion. The man thought he was being followed for 4 years and modified his life accordingly. And it is a simple error of law to fail to have regard to the guidance as the Equality Act requires.
Is there a system with the tribunals where if you think that they've left out something obvious, you can say, could you please deal with this?
There's a mode of reconsideration. Reconsideration or review.
Yes, but I mean in the context of a handed-down decision.
Yes, you can.
I mean, presumably, if somebody gives an extemporary judgment, you can stand up and say, would you mind dealing with my fourth and best point, which you don't seem to have covered, whereupon the tribunal does or doesn't do so. But, I mean, are we in a situation where the Employment Tribunal was tasked with saying what it thought about the guidance?
I mean, was the guidance referred to by the parties, for example, in their were there closing written submissions in this case?
There were closing written submissions. I'm not sure if it was. I should say I didn't act at first instance.
No, but if the parties are legally represented, as I think they were, and the tribunal wasn't referred to the guidance, but they considered whether or not the delusions met the statutory definition, I'm not following at the moment how they are to be criticised.
Well, they have to grapple with the question, my lady, as to why it was not reasonable to have regard to the guidance or reasonable to depart from the guidance.
Mr. Lee will know, but we've only got parts of the documents that are for the tribunal, but one of the good things, and on my experience today, one of the only good things about having an electronic bundle is that I can find out whether they were referred to guidance. Indeed they were, and by Mr. Lee, but not by the appellant, according to a search of the word guidance within the...
Well, there we have it.
Within the bundle. So, yes, it was squarely before the tribunal, and we find it in page 219 of the supplementary bundle, where all the stuff that you've been taking us to is set out there perfectly plainly for the tribunal to see.
Yeah. And whilst parties may be encouraged to raise points with the tribunal to challenge or seek a reconsideration, etc., they're certainly not required to, and it doesn't avoid the conclusion that the judgment as it stands is erroneous.
Is what?
Is erroneous. It fails.
Because they don't expressly mention something.
Well, I've taken you to paragraph 212. Paragraph 12.
No, I understand that proposition, but I do, speaking for myself, I do begin to worry. I mean, this court and other courts have often said, in many contexts, that lower courts and tribunals are not, as it were, sitting an exam paper. We do have to ask ourselves, in substance, what was going on. And I understand your submission that they ignored the guidance, but the mere fact that you don't mention something doesn't mean that you've ignored it.
Well, the reason I flagged Anya, my lord, is I hope obvious.
Yes.
If there are difficulties in this judgment, then it cannot be presumed where something is conspicuously absent from a judgment that it has been taken into account.
Yes.
Ground 2, long-term and recurrence. The first point I wish to raise is one of correct statutory construction. Paragraph 5 of Schedule 2 of the Disability Discrimination Act, which we see at tab 26, the authorities bundle. This is paragraph 5 of Schedule 2 of the DDA 95.
Sorry, which provision?
This is paragraph 5 of Schedule 2
Yes,
of the Disability Discrimination.
Effective medical treatment.
No, this is in the Schedule of Past Disabilities, but it seeks to introduce wording to Schedule 1 of the then provisions of the DDA, which covers the definition of
I haven't got the right page, I'm afraid. What page is it?
It's tab 26.
Yes, I have that.
The very last page of tab 26.
Very last page, right. This is the DDA 95.
Yes.
Paragraph 5 of...
Paragraph 5, Schedule 2
Right.
of the DDA.
Yeah. Now repealed.
Now repealed.
Yeah.
But in force until the 30th of September. Equality Act came into effect on the 1st of October. Where an impairment ceases to have a substantial adverse effect on a person's ability to carry out normal day-to-day activities, it is to be treated as continuing to have that effect if that effect recurs. If that effect recurs. In other words, if there is at the point of the material contravention a recurrence, there is no need to speculate. There is an ongoing substantial adverse effect.
Yes, the words "to be treated" are often used in legislation as a deeming provision. So this appears to be, is this right, a deeming provision? That in other words, the real facts may be X, but the facts are to be deemed to be Y.
Yes.
Is that right?
Yeah.
All right. But this has been repealed.
It has been repealed.
So what are we looking at?
Well, might be an obvious question. The purpose of the Equality Act was to restate and, in considerable respects, enhance protection that formerly existed. There is no instance of the Equality Act regressing from the protection which was formerly enjoyed.
But this might be one. Because it's missing, as I understand it, it's missing from the current provisions. This deeming provision is not in the current provisions.
The legislative purpose of the Equality Act was to restate and, in several respects, enhance. I'll
So where do you get the legislative purpose? Is this from the long title?
Legislative purpose from the long title and also addressed by Lord Justice Underhill.
But isn't the real guide to Parliament's intention the language that Parliament's used in the predecessor legislation and in the current legislation?
Well, read the statutes is of course the fundamental rule of statutory construction, and read the natural words. I accept that.
Yeah.
Can I take you on the correct approach to the Equality Act, though, to tab 14, Blackwood and Birmingham and Solihull Mental Health NHS Foundation Trust of this court, the judgment of Lord Justice Underhill, paragraph 39 of that judgment. This was in the context of liability of a university and a work placement provider. And on the natural reading of the Equality Act, protection that formerly existed, the ability to pursue claims which formerly existed, had been removed. And you'll see the submission that was made at paragraph 39. That was adopted by the court at the end of paragraph 52C. Blackwood is one of 3 examples to date of this court identifying that the natural wording, whilst the natural wording of the Equality Act might suggest some measure of regression, Parliament is to be presumed as having no such intention. Blackwood, Jessamy and Rostock, which is cited, and an equal pay case, Asda and Brearley. It would be surprising, I submit, if had the recurrence in 2017 started on the 30th of September 2010, the position would be any different if it started on the 1st of October 2010. Particularly where there are a number of features of the framing of disability under the Equality Act which were expressly designed to facilitate the establishment of a disability. Can I take you to tab 25? And the explanatory notes at 674.
So tab 20.
Tab 25. It's the penultimate page of tab 25.
Tab 25, I have the Equality Act.
Tab 20, that is the Equality Act, yes.
Right.
I'm taking you to the explanatory notes of the Equality Act.
I'm afraid I don't have that.
Yeah.
Page
Second last page of that tab.
Yeah, that's it.
I think somebody's put it behind the wrong tab, but I'll try and find it.
Apologies for that.
No, I'm afraid I can't find it.
This change will make it easier for some people to demonstrate they meet the definition of a disabled person.
Yes, so it used to be under the DDA that there were 8 capabilities, one of which was perception. But now, simply focus on whether there is an impairment which has a substantial...
I'm sorry, Mr. Milsom, I found the explanatory notes. What paragraph is it?
674.
Oh, yes, I have that.
And that, in the present context, we're assisted by 675. Where fluctuations of depression over the course of an underlying mental health condition are to be treated as long-term, where the effects, where they do take place, are substantial. we say that's on all fours here. Just finally on the interpretative material, the guidance again, tab 28. And the examples in the guidance, internal numbering, page 30 at the bottom on recurring conditions. And the second example, 2 discrete episodes of depression within a 10-month period. No evidence that these episodes are part of an underlying condition. If, however, there was evidence to show that the 2 episodes did arise from an underlying condition of depression, the effects which are likely to recur beyond the 12-month period, she would satisfy the long-term requirement. That's suggestive that where there is in fact recurrence at the point of material contravention, the individual is covered. There is, of course, a well-known principle why that should be so. A court should never speculate when it knows, at least when it knows at the point of the material contravention.
But that's not what this says. It says, if there was evidence to show 2 episodes did arise from an underlying condition of depression, the effects of which are likely to recur. So it's not saying because there have been 2 episodes, you can or must infer that there's a likelihood of recurrence. It's saying that's an additional requirement.
Well, my lady, what I say on the question of construction is that given the trajectory of the legislation, the move from 8 capabilities to that which is limitless, designed precisely to ease the proving of disability, the express statutory recognition that substantial means no more than minor or trivial, the question of likelihood in a recurrence case should be construed so as to reflect the former coverage under para 5 of the DDA. In other words, where there is at the point of the material contravention a recurrence, the tribunal should proceed on the basis that there is a likelihood of recurrence.
But the guidance isn't telling tribunals to do that.
Well,
this passage that you've just shown us doesn't say that.
Well, the guidance does not address the repeal of para 5.
No.
There is nothing in Hansard which addresses the repeal of para 5. There's nothing in the explanatory notes which suggests which assist on the interpretation of the repeal of para 5. What we say is that, as in Jessamy, as in Blackwood, as in Brearley, Parliament should not be taken to have removed coverage of the disability provisions where it formerly existed. That was expressly not the purpose of the Equality Act.
Well, it might not be the purpose, but it seems to be the effect of the repeal without reenactment of that provision, isn't it?
Well, my lady, this would be the first instance of which I'm aware where an appellate court were to conclude that the effect of the Equality Act, the legislative purpose of the Equality Act, was to remove coverage for disability provisions which formerly existed.
Well, it's not a question about the legislative purpose. The question is, what has Parliament done?
The question is, what is the effect of that? And I submit that the effect of the removal and focus on likelihood means that the likelihood provisions are deemed to be satisfied where there is in fact a recurrence at the material time. Because otherwise the effect would be to treat Mr. Sullivan differently had the recurrence taken place or had the recurrence ended on the 30th of September as opposed to the 1st of October. That would be a surprising outcome, wholly contrary to the purpose of the Act. In any event, the question of likelihood, whether it assessed as to likely duration or likely recurrence, parties agree the test is whether there is a real possibility of recurrence, whether it could well happen. And part of that picture is whether, when there are coping strategies, whether there is some prospect of those failing. Can I take you to tab 18 of the authorities bundle, which is the case of Parnaby. In which the tribunal concluded that the specific episode, which otherwise met the definition of substantial adverse effect, was not likely to last or was not likely to recur because the stress-related reaction was a response to the prospect of dismissal. And since dismissal would be resolved imminently, there was no prospect of recurrence. The EAT concluded that the tribunal had fundamentally erred in approach. Then Her Honour Judge at EDQC at paras 25 and 28. And really 2 points are made in those paragraphs. Firstly, one can't look at the likelihood of recurrence by reference to an act which was the very basis of the disability discrimination claim itself. It's not enough to say that the ending of the work was the causing of the stress at issue when the ending of the work was the basis of the complaint. It's para 25. And then 28 identifies what the tribunal must do, which is to look at the different possible life events that might happen, which might include no longer working for the respondent, and consider whether there is a real possibility of lasting beyond 12 months or recurrence. That is echoed by the case of Dawoodi, a CJU decision which was put before the EAT below, in which the CJEU concluded that notwithstanding the fact that an individual had only been absent from work for 8 months, because of the indefinite nature of the prognosis and the obligations of the UN Convention on Disability, temporary unfitness, where it does not display a clearly defined prognosis, may nonetheless meet the requirements of long-term, particularly where the purpose of both the directive and the UN Convention is to tackle barriers that hinder participation at work, and the decisions the employer was contemplating was dismissal, the greatest barrier to work of all. Now, my learned friend in his submissions takes you to the extracts of Harvey, which are at tab 29. I don't propose to turn them up now. The point being taken that Dawoodi is wholly consistent with the approach towards likelihood of duration or likelihood of recurrence domestically. We agree. And that's precisely why, where there is no definite prognosis, it must be taken that there is a real possibility either of recurrence or of duration beyond 12 months. How can a tribunal confidently conclude otherwise? Now, on that, I turn to the approach of the ET. So ground 2 only arises if you're against me on substantial adverse effect. It's whether at the point of dismissal there is a likelihood of duration beyond 12 months or duration beyond of duration of recurrences. The analysis we see at page 131 of the core bundle. In which the tribunal first considers likely duration beyond 12 months. The tribunal found that during this period it was not likely that substantial adverse effect would continue for at least 12 months. 2013 lasted for approximately 4 to 5 months. During the period in 2017, the claimant was under particular stress by reason of the discussions about the basis for his remuneration. They were not going to continue indefinitely, and it was likely that his condition would improve when they were resolved. The tribunal concluded that so far as this episode in 2017 is concerned, it was likely that the substantial adverse effect would continue like that in 2013 for a number of months, but for rather less than 12 months. And then for substantially the same reason, the same point is made on recurrence as well as likely duration. The first point worth stating is that the tribunal has erred at an error that would have been rectified had it taken account of the guidance at paragraph 103. Because the last sentence of paragraph 103 requires the tribunal to have concluded, the last sentence of paragraph 3 suggests that the tribunal was proceeding on the basis that any given recurrence had to last 12 months. That's just wrong in law. And if you're with me on the DDA point, he's done enough at the point of dismissal because there is in fact a recurrence. Alternatively, likely should be interpreted so as to restate the previous protection.
Right, so this is only an error of law if your submission about the survival of paragraph 5 of the whichever schedule it was to the DDA is correct.
Well, it's an error anyway in my submission, my lady.
Right. Sorry, well, I misunderstood what you said.
Because what one doesn't need in an underlying condition case is for any given episode to last 12 months. That's what the guidance says, that's what the explanatory notes say. The tribunal has, whether the error is material is of course another question, but it is certainly an error to say that any given episode must last 12 months.
All right.
Should it be, in neither case was it more likely the substantial adverse effect would arise again within 12 months?
Well, there's already been 4 years since the first episode.
All right. Well, how are you doing, Wilson?
My lord, I was hoping to... I'll stop now.
No, I don't want to cut you off. I'm just anxious to know where you've reached in your submission.
Let me deal with this train of thought very, very briefly.
Well, is that the end of your submission at that point, or have you other things to go on to?
I need to... I've probably got a couple of words on...
Yes, so how long more do you need?
15 minutes?
At 2 o'clock. Thank you.